McQueen.
Yes, Mr. Salt.
My Lord, we're dealing with time of death and the failure of trial counsel to call evidence to rebut the Crown's time of death evidence. We'd covered the evidence of Dr. Pang and his reliance upon the stomach contents and gastric smell. We'd covered his time of death estimate of 1 hour 10 minutes, which would put the time of death between 7 p.m. and 7:15 p.m. We'd provided references which we say demonstrated the precision with which he made this or opined this. We next go on to the respondent's point, and they argue that Dr. Pang did not hold himself out as an expert on time of death estimates based on stomach contents. If that be right, of course, he ought not to have given the evidence that he gave. But in fact, as the transcript demonstrates, he did in fact hold himself out as an expert, and we refer to page 955 of the transcripts, lines 4 to 7. It's also right to note that certainly the Crown, in closing their case before the jury, held Dr. Pang out as an expert on stomach contents. Cross-examined, Dr. Pang was cross-examined as to the significance of smell of gastric juices, and the reference for that is page 956, line 30. Pang says that it is in our textbooks, and the references there are 957, line 4 to 7, and 960, lines 15 to 21, the re-examination. Your Lordships will recall that Dr. Pang was recalled to the witness box after being invited to go and seek out the texts upon which he relied. He came back, was cross-examined, and it was suggested to him that the passages to which he was referring the court to did not suggest that stomach contents or gastric, or more particularly gastric smell, was a determinative factor in estimating time of death. The reply by Dr. Pang was that the texts were inconclusive about that issue. So no repudiation by him at that time in the trial or withdrawal of his earlier opinion.
My impression was that the cross-examination was as effective as it could possibly have been, really, wasn't it? I mean, the jury would be well aware of the nature of the challenge, and obviously they had to make up their minds whether to accept it or not.
Yes, yes. Although it's right to say during the cross-examination, it's clear that no inroads at all were made on the 1 hour or 1 hour 10 estimate upon which the Crown placed considerable weight to prove their case.
Well, when you say no inroads were made, a direct challenge was made to it, was it not?
A direct challenge, but of course, in the absence of calling witness, that's what it remained.
Well, Dr. Pang returned and produced a text which, on your case, he asserted supported him, but on proper analysis failed to provide that support.
Yes.
This was all a matter before the jury, wasn't it?
Yes.
The jury could make up its mind whether his evidence was acceptable or not. I mean, it wasn't as if it had gone unanswered.
And the trial judge made it clear that this is a point of real importance for them to fasten on. I think he used the word essential, an essential part of the Crown case, and really something they had to give very careful thought to. My point really is I'm a bit doubtful at the moment, but no doubt you'll clarify this later, as to where this is taking you in support of your appeal.
The point that we make is that the fresh evidence that we've put before the board confirms that, in essence, one couldn't tell from looking at the stomach contents in this case what the time of death was. In essence, because of the failing of the pathologist to, for instance, weigh out the stomach contents, nobody knew when whether digestion had started or not. It was just, one could never know. And whilst trial counsel says, well, Mr. Stables was going to say, as I understood it, that stomach contents could be consistent with the time of death of an hour and a half. That wasn't the full story, of course. The full story was that you cannot tell. And that's the point that we make. The jury, what the jury weren't told, because of the decision not to call either Stables or Venisi, was that, contrary to what Dr. Pang was saying, the stomach contents were equally consistent on Stables and Venisi's evidence with the latter time postulated by the defence. And so that's what the jury were deprived of. And that was the, we say, the real concern of that decision making. So the jury were left with only part of the equation.
Well, I think the word consistent is quite interesting. I mean, you say, well, in view of the information you're now putting before us, it's equally consistent with either theory.
Yes.
But at the same time, it could be said in support of the Crown case that the evidence that was given, defective though it may be, was consistent with their theory.
Yes.
You couldn't
I accept that, but again, it comes down to the point, what the jury were deprived of was knowing that it was equally consistent with the postulated defence case. And that was a primary concern. In that, Dr. Pang, having finished his evidence, I should also add, of course, the decision made not to call any evidence to rebut Dr. Pang's evidence left the jury in a situation where they had been told, and there was nothing to gainsay, that gastric juices was a determinative factor in time of death, because of course after Dr. Pang was called, Dr. White was called, she confirmed as such, and then Professor Barbezet, he told the jury the absence of gastric smell was very striking in this case. Well, according to the evidence that we seek to put before the board, nothing could be further than the truth. So the jury were in effect misled on that point because of bad science, and were left in a situation with half the equation insofar as time of death from Dr. Pang was concerned. Moving forward, at paragraphs 47, 48 and 49 of our skeleton, we refer, of course, to the other evidence in the case. And that is the other evidence that we suggest tended to support the defence case. The lights on evidence, whereas in the morning when the brother arrived, the lights were off. The overwhelming evidence at trial was that Christine Lundy was a person who went to bed at about 11 p.m. Or later when her husband was away, and never as early as 7 p.m. That was the evidence in the trial. Amber's bedtime was 7:30 p.m. and lights out at 8 p.m. And the evidence in the trial was that Christine Lundy strictly enforced that. So there was a body of defence evidence, a body of evidence to support the defence position, and it's in that context that the missing pathology really did make a difference to the defence case before the jury. And we say that's a judgment call, difficult to understand. And that's the submissions we make in in the appellant's case. It's difficult to understand because if we look, please, at the affidavit of Joe Jessup at volume 7, tab 34, and might I take the call, please, to 2643. And it's over the page at 2644. We see a letter dated the 12th of July from Mr. Stables, the defence pathologist, and the second paragraph, 3 lines up from that. In addition to the above variables, it is only after taking into consideration all these factors one might be able to give a rough time frame in which death may have occurred. However, I myself would not take that position. So here's Stables. He's discussing in that letter the issue of the emptying of the stomach. He's saying that one might be able to give a rough time frame, but he wouldn't take that position. And as we know, he made available to trial counsel.
What was the question that he was answering? That's on the previous page, is it?
Yes, yes.
Yes, so the Crown case has been put to him in the second paragraph.
Yes, yes. And then I wonder if you would be good enough to read the post-mortem report and just indicate in general terms the reasons why a deduction of time of death from the stomach contents can be an unreliable process. And in essence, the answer is provided over the page.
The proposition in the previous paragraph is putting a fairly precise time frame.
Yes, exactly as what we say the prosecution was in their case. So it seemed on the face of it, of that advice, that Mr. Stable's opinion was wholly inconsistent with the evidence of Pang and Barbezet at trial. Moving on volume 7 still at 2646. It seemed by the 16th of January 2002 that trial counsel was still seeking advices from experts in relation to the issue of gastric juices. And there we see an answer, a question being asked by trial counsel about that. And the answer we see comes rather graphically at 2647 when the expert says what he does. The short answer is bullshit. The food contents take an average of 2 to 4 hours to digest, etc. And then he goes on and said, well, smell has nothing to do with the equation. And we picked that up at 2649.
Just remind me, what time was the meal bought from McDonald's?
5:38.
5:40.
Sorry,
is it 5:43?
5:43, I'm sorry.
5:43. 5:43.
So an average of 2 to 4 hours to digest. On that answer, it'd be fully digested by 9:43, is that right?
Yeah, it would seem to be on that particular expert's opinion.
It could be fully digested by 7:43.
Yes, that would follow from that.
Well, the thing was bought at 5:43. You've got to get some time to actually eat the meal. And presumably, was it taken home? I mentioned it was bought at McDonald's.
6 o'clock and 8 o'clock, yeah.
Yes.
So I think sort of 6 p.m. would be the time.
From that time.
The critical issue, though, is the start of the digestive process, is it not? Not the completion.
That's right.
Yes.
That's right. And it's the start of the digestive phase that we don't know about because of the shortcomings of the pathologist's examination. And the point is, the stomach shrinks and expands to fit its contents. And unless one weighed the stomach contents, one doesn't know, according to the defence experts, one doesn't know whether the digestive process had started or not. So that's the difficulty.
Wasn't the bowel empty?
I'm sorry?
My recollection is that the
duodenum.
duodenum was empty.
Duodenum, our experts address, that mechanism works so quickly that as particles pass through it, they're in there for a very, very short time. And the beginning of the process, the duodenum and the intestines are 20 feet long, and they disappear, in essence. That's what the experts say. And as there wasn't a proper examination of them, and Dr. Pang did concede that in the trial, it couldn't help. And Dr. Pang said as much in his evidence.
Can you give us the reference to that?
Sorry. I will. I haven't got it at the moment. I'll get it. Yeah. On that issue, the board may be assisted by going to volume 6, and we would suggest tab 32. And this is the affidavit of Professor Nicholas Darmont, and he addresses those matters at paragraphs 10, 11 and 12.
Well, your duodenum point is paragraph 15 on 2538.
My Lord, yes. We know that on day 20 of the trial, the 27th of February, trial counsel emails Professor Venisi. We have that at volume 4, page 1888, and he was writing to Venisi and he said, "But I feel I really should call expert evidence about the path findings and opinions." And by the 1st of March, there is a discussion between an email exchange between trial counsel and Professor Venisi's PA, and that's at 1889, about costs of travel. And then, of course, 1 month into the trial counsel receives Professor Venisi's report, dated the 6th of March 2002. And if we could go to that, please, at volume 4.
Are you coming back to is it Dr. Diamond's evidence?
Yes.
You are coming back to it, are
Yes.
you? Yes, thank you. So we're looking at volume 4.
Yeah. Volume 4, and it is page 1894.
Which tab, please?
That will be tab 10.
Yes, 1894.
Sorry,
1894.
Very near the back,
I
isn't it? Mrs. Venisi's.
This is Venisi's report, and it's paragraph 4 to which we refer. He therein rehearses Dr. Pan's comments regarding his estimation of the time of death. And further down he says, "I find no scientific grounds for such a view to be held. It appears that this conclusion is reached on taking into account circumstantial information provided regarding the time of purchase of a meal. In this respect, I beg to differ with both Drs. Pang and Professor Bezett's views." And then he addresses the standard ways and means of determining time of death, but doesn't include stomach contents. In essence...
It's interesting to see paragraph 5. So temperatures were not taken.
No.
And testing for rigor mortis not carried out either.
No.
Curious omissions.
Nothing by way of traditional means to determine death was done. What in fact the evidence in the trial was that Dr. Pang attended the scene and looked at the bodies from the doorway of the bedroom and approached them and didn't approach them any closer than that. And that was the evidence in the trial. And so that is why the experts upon which we rely in this case, Professors Bernard Knight, Cicely and Diamond, are critical of Dr. Pang, and not only of his evidence, but of his the way in which he carried out his duties as a pathologist.
Was Dr. Pang cross-examined about these matters, not looking for rigor or hypostasis? Presumably he was.
Yes, he was. He was.
And his answer was?
His answer was, I couldn't do that because I didn't want to interfere with the bodies.
Didn't want to disturb the scene?
He didn't want to disturb the scene.
Yeah. By the time you get to the post-mortem, it's too late.
It's too late. And as the defence experts point out, he could have taken temperature without disturbing.
Maybe.
Right.
But all that was canvassed in cross-examination?
Not that particular point, no. the defence experts upon which we rely, Professors Bernard Knight, Sisleteria and Demont, in essence they say there was no attempt by Dr. Pang to weigh the stomach contents, and as I said before, because the stomach shrinks or expands to accommodate the size, no telling when digestion started. They further, of course, note that the stomach is a poor timekeeper when it comes to determining death, and the suggestion that gastric smell is a determinative factor, they say, is bad science.
Where does this evidence lead your theory? I mean, the post 10:28 p.m. theory. I'm looking
Can I go to Professor Diamond's?
Yes, page 2538, paragraph 16 of Professor Diamond.
Yes.
Makes me wonder whether he really, on his view, which is talking, he's saying, well, you've got to be very, you talk about this in terms of hours, spans of periods of hours, really, in assessing this. You can't be as precise as the Crown was suggesting.
Yes.
On the other hand, you've got to stretch it quite a period from the eating, at, let's say 6 p.m.
Yes. My learned junior makes the very good point, although the defence, of course, were postulating 10:52.
Yes.
All the defence really had to do was stretch it beyond 7:15.
I do see that.
And the man, then the travel to Wellington, it becomes an impossibility, and he has an alibi.
Right, yes.
Well, except that you've got another 3-hour gap, haven't you, between 8:28 and 11:30?
Yes. 8:28, he's in Wellington.
And 11:30 is in Wellington.
Exactly.
And
it's
about 3 hours.
Yes. The difficulty one then gets is, of course, on the Crown case, Margaret Dance sees someone who, on the Crown case, they say is the defendant at 7:15 or 7:20. And the Crown had opened their case on that basis.
Yes.
So, in reality, although it was the defence case that time of death must have been after 9:52, they really, to succeed in their defence, only had to prove time of death after 7:15.
But it wasn't the defence case that Mrs. Dance had indeed seen.
Oh, not at all.
Quite.
Not at all.
Or indeed anybody.
Or indeed anybody.
Yes.
Yes. We were looking at paragraph 16 of Dr. Diamond's affidavit, and the contents thereof speak for themselves, and as we say, the point was that the defence only had to stretch it beyond 7:15 to make it an impossibility. Trial counsel was given the opportunity to advise this court as to why it was that he didn't call the evidence that was available to him. He gave two reasons, and they are set out at volume 7, page 2588. And in fact, to save going to that, we set that out at paragraph 132 of the appellant's case. In essence, trial counsel spoke to Dr. Stables and was told, I asked him whether he would agree that the state of the stomach contents could be consistent with death shortly after consumption of food in question. He said yes, and thereafter trial counsel gives his reasons why he didn't call. As we said earlier this morning, that decision meant was the jury weren't told, contrary to what Dr. Pang's evidence was that these stomach contents were equally consistent on Stable's and Venesi's evidence with a later time. Now,
Wasn't that implicit, though, in what they were told, or the inroads that were made in cross-examination, that it was not possible to be certain?
Well, certainly on Dr. Stable's cross-examination, he left the jury with the very firm impression that he could be minutes out, but certainly not hours. And that's very...
Sorry, Dr.
Pang.
Sorry, Dr.
Pang. I think you said Dr. Stables.
Oh, I'm very sorry.
That's all right. No, that's all right.
I mean Dr.
Dr.
Pang.
Pang.
Do you mean Pang or do you mean Barbset? Because the principal, I mean, you're quite right, Pang professed himself an expert, and the suggestion that he didn't, we shall have to wait and see whether it's pursued, but the principal expert was Barbset, wasn't he?
Yes. And again, he postulated in minutes,
Right.
not hours. And so we would say it certainly wasn't implicit in the evidence before the jury that the hypothesis by the Crown was equally consistent with a later time.
I think that the point my lady makes to you is a forensic decision has to be taken by defence counsel. Here, he's being told by his expert, well, if I get into the witness box and I'm cross-examined, I may have to say that it's consistent, that the prosecution theory is possible. And it may well be that Mr. Behrens took the view, well, I have made sufficient progress in cross-examination, I'm not going to expose my expert to possibly damaging concession.
The frank answer to that is, on any sensible reading of his cross-examination, he hadn't made any inroads at all that were going to assist.
Well, that's a value judgment, I think.
He hadn't got concessions, Mr. Hislop, there's a difference.
Yeah.
He may not have got the concessions, but is it not every defence advocate's experience that the high point of the defence case is nearly always at the end of the Crown case? You start going downhill when you start calling evidence and taking on the burden of having to establish something.
I accept that, and trial counsel has to make those decisions almost every day, and I accept that. But it's the context in which that decision is made, and the context, we say, is after cross-examination, the jury were left with the view that variation could be down to minutes and not hours. And in the face of that, we respectfully submit that a wrong decision was made and the jury were deprived of the available evidence that would have contradicted Pang and Barbset on time of death.
Could we look at page 2588? I mean, I looked at that rather than the bit in your case that you were referring to. This is volume 7, tab 33, and it's a quotation from trial counsel's email, which explains quite fully the decision he took. And the danger, as he saw it, was pressing the jury to think of an alternative timing, which actually was rather, I mean, from the prosecution's point of view, it got over some of the difficulties in the evidence which he thought he could rely on. And I can understand from what's being said here that there was quite an important decision to take as to whether it was wise to do that.
Yes.
And what as we look at it now, can one really say that was a decision which no responsible counsel could possibly have taken?
The reason postulated is that that fear that the prosecution would change its position. It is completely. One can't imagine the circumstances where that could be a reasonable belief. In opening the case, the prosecution nailed their colours to the mast and put time of death at between 7 and 7 p.m. By day 20, when he made the decision not to call time of death evidence, by then the Crown had called Margaret Dance, who put their case 7:15, 7:20, citing of the man they said was the appellant. It would mean that the Crown would have had to have abandoned Margaret Dance and abandoned all their evidence from Mr. Kleincheese about manipulation of the computer. It is inconceivable, we say, that the Crown would have
Sorry,
changed.
is that right, that they'd have had to abandon Kleincheese? Because there were two opportunities, two further opportunities. The 3R one that is mentioned from 8:30 to 11:30,
Yes.
roughly. And then there's the idea that it's in the early hours of the morning. So Kleincheese would be required in any event for the second opportunity.
Yes.
Yeah.
Yes, I concede that will be right. But it would have been a complete U-turn almost on how the prosecution opened the case.
Well, it may have been. But what about the possibility, have you considered the possibility that the judge might have felt obliged to direct the jury, members of the jury, what you've got to decide is whether he killed her. You haven't got to decide when.
The difficulty with that direction would have been, the defence was, I wasn't there,
Yes.
I was in Wellington,
Yes.
I've got an alibi
Yes.
of parts. Well, leaving it open-ended.
It depends what evidence there is. As things stood, the judge didn't feel he did that. He felt that the Crown had committed itself,
Yes.
and that he was obliged to give the direction which he did, which
Yes.
put it into the, as it were, the first window, or none. But from the point of view of trial counsel, who's considering what evidence to call, is he or is he not entitled to take into account the more evidence he calls, which tends to show that if he did it later. If he did it later. The greater the danger that's what's going to emerge as the direction. I mean, these are the things that you have to think about when you're defending people, aren't they?
Yes.
You've done it. I know.
Yes, but it'd be wholly unusual for the Crown to assail.
Yes, I see.
Especially having called Margaret Dance. But that's how we put that.
Could you remind me what the point is about the glasses? I'm afraid I haven't picked this up.
It's a small point. The evidence at trial was that Mrs. Lundy had very bad eyesight, and if she had her glasses off in bed, it would seem to suggest that she wasn't reading in bed, and the way the
point to later in the evening, then.
Yes.
Yes.
Yes. And so it's just part of the body of the rest of the evidence that supported the suggestion that she didn't go to bed at 7 p.m. That wasn't her habit. She was effectively a night owl. was the impression one gets from reading the various witnesses called by the prosecution.
Was there evidence, Mr. Hislop, about what her habits were about nightwear? Or not?
Yes, there was.
And
She regularly went to bed with no clothes on.
Right, okay.
Yes. Going forward, just to sum that part of our submission up, we say the pivotal nature of the time of death would have been readily apparent to any competent trial counsel, and especially in the setting of he having made very little progress, we say, in cross-examination, shifting the 7 p.m., 7:15 time of death. The law we set out in our paragraph 137 of the appellant's case. The materiality we set out at paragraphs 138 through to 149, and we again make the point at 150. Clearly the uncontradicted evidence at trial of the pathologist as to time of death, we say, bearing in mind the contents of the affidavits to which we have referred, supports the suggestion that his evidence was not founded on any valid science. As to the time of death evidence being fundamentally flawed, can I take the court, please, to Professor Knight's affidavit, volume 5, at 2091, that's tab 15. And it's paragraph 18, please. I regard the use of stomach contents as an estimate of time since death as so unreliable as to be of little value. The overwhelming consensus of forensic pathologists worldwide is of a similar opinion in my long experience. There are numerous variables which make gastric contents almost useless to determine time of death. And then at paragraph 19, I particularly question the Lundy pathologist's Pang's evidence that absence of gastric smell was and is an important determinant of time since death in the murders of Christine and Amber Lundy. I consider this to be utterly without foundation and little short of ludicrous. I'm conversant with virtually all the literature about estimation of time since death, and I've never heard of such a contention. And over the page, at paragraph 20, I similarly reject the evidence of Barbezit. He had not attended the autopsies and had not inspected the stomach contents. He evidenced that the absence of gastric smell was a striking finding by Pang, whereas it is my opinion and that of my colleagues who refuted the claim with derision, utterly without foundation. 21, I understand that Christine and Amber Lundy were alleged to have been murdered at 7 p.m. with a window of no more than 20 minutes around the time if Lundy was to be found guilty. In my opinion, such a precise time of death cannot be deduced at all accurately and reliably from stomach contents and absence of gastric smell. It's not a determinant at all. Moving on, in summary, Professor Knight concludes that the very grave doubts surround much or even all of Dr. Pang's findings, and we find that opinion in his second affidavit, volume 6, tab 27, at page 2357.
Page 2387 is where it begins, and
235, sorry.
is that tab?
No,
27.
tab 27.
Yeah.
And it is, I've got a wrong reference, I'm sorry.
Which paragraph do you want us to look at? I think we'll be able to find it if you tell us the paragraph number.
Oh, yes. I can, if I can go please to 6G.
Yes, that's at 2390.
Yes, I'm sorry. Dr. Pang's estimate time of death to within an hour based on stomach contents of both victims' gastroenterology simply does not permit such precision. He now opines that the digestion was in the lag phase as opposed to the emptying phase. In this regard, I refer to the following passage summarising Dr. Pollin's evidence in Truscott, and it's set out there in the affidavit.
This is curious dialogue going on here. This is Dr. Pang long after the trial, trying to justify his position, is he?
Yes, yes, yes.
Dialogue might be a euphemism.
Done?
Dialogue might be a euphemism.
If we could then go, please, to Professor Helen Whitwell's affidavit, and we find that at volume 5, tab 13.
So, sorry, I'm just trying to think aloud here. Your case really is that because the window of opportunity that the Crown was relying on was so small, it wasn't enough to have evidence or acknowledgements that this wasn't exact. The jury should have been told that it was impossible to estimate cause of death from gastric contents with such precision.
Yes. My lady, yes. Yes. Going to volume 5 and tab 13.
Yes, and you would say that the significance of this in a larger picture, I mean, again, just thinking aloud, is that on the assumption that they ate the meal as soon as they got home from the McDonald's, they're eating the meal roughly 6 o'clock. So we have an estimate, I think, of about an hour from, is it no more than an hour from,
Yes.
from Pang, so it's so he's taking it to about 7, and that then fits with Mrs. Dance's evidence about seeing someone who might have been the killer who is broadly similar to the appellant at about 7:20, going back to his car, and this I think, as the trial judge points out, is right in the middle of a 3-hour window,
Yes.
and therefore fits with the drive to, from Wellington and back again. Yeah.
Yes. Yes. And that's why we say this evidence was pivotal.
Sorry, this evidence was?
Pivotal.
Pivotal, yeah.
And indeed, that was the point the learned trial judge made in his
Yes.
directions to the jury.
Yes.
Paragraphs 11 and 14. Going back to Professor Whitwell's affidavit, if I may, and her report, which is exhibited, and we see it at 2030. And it's the comment at 2. With regards to the reliability of the use of stomach contents as an estimation of time of death, this is completely unreliable and well recognised to be so. This is because that the digestive processes varies from individual to individual. And then she goes down. In addition, it is well recognised that portions of a meal can stay within the stomach for some considerable length of time, including up to several hours or more. I note that the amount of stomach contents was not measured in this case. This would be usual practice. I am unaware as to any literature which relates to estimation of time of death from the smell of the stomach contents, and would say that this factor is completely unreliable and without scientific basis. Of course, the jury were deprived of all that information as a result of the decision not to call expert evidence to rebut. I won't take the court to it, but Professor Paul Cisletera, Professor of Gastroenterology at King's College London, has looked at, of course, the affidavits in this case, Dr. Pang's evidence and Professor Barbezet's evidence, and he opines that the timing based on gastric emptying is simply incorrect, and the reference for that is volume 6 at tab 30. He says in his very short affidavit that the use of gastric smell is a scientific nonsense.
I think he gives a margin of 6 hours either way.
Yes.
So he's even broader than some of the others, actually,
Yes.
isn't he?
Yes, he is. Going back to Professor Diamond at volume 6, and that is at tab 32. Paragraph 6, he points out that gastric emptying is a very complex phenomenon. And reading over the information I've been provided, including the testimony of Professor Barbezet, I do not consider his concentrating on and descriptions of the durations of the lag and emptying phases and gastric acidity in order to specify a time of death to be a very limited time period, not able to do that, or are able to do that. It doesn't make sense the way it's written, but he goes on. As the evidence I provided in the Truscott case stated, there is a wide variation in the range of gastric emptying. And this is also true for the digestive process, and he refers to an article in the Australia-New Zealand Journal of Medicine, and he lifts a paragraph from there. Third, the confidence limits of any opinion should take into account the many possible variables, so that the estimate given should cover a range of at least some hours. Estimates to within half an hour clearly cannot be justified in the light of present knowledge of patterns of gastric emptying. For forensic purposes, the stomach is a very poor timekeeper. He makes the point at paragraph 11 that Dr. Pang's opinion that there was no obvious signs of digestion was not based on a careful examination of the gastric contents, and he elaborates on that in that paragraph. And then he confirms what the other defence experts confirm, of course, that there is no scientific basis for suggesting that smell of gastric contents is a determinative factor in time of death. And that's, as I say, referred to at paragraph 12. He explains his position in that regard at paragraph 13. And then more materially at paragraph 12, and it's the last sentence in that paragraph, it is well described in the literature that recognisable solid food can be present in the normal stomach for at least 6 hours after the meal was eaten. And that seems to coincide with Professor
yes.
Paul Cislatera.
Yeah.
And just digressing for a moment on that, we have photographs that went before the jury, and at photograph 125, the jury's attention was brought to a photograph of the stomach contents.
You'd like us to look at this, would you? You'd like us to look at the photograph, would you?
Yes, thank you.
125?
125. So, $125 at the bottom, right hand.
Does it purport to be the entire contents?
No, those are pieces of food undigested or seemingly undigested. A photograph of which went before the jury, doubtless to demonstrate that the evidence that Dr. Pang was giving.
Yeah.
And of course, we know from certainly Professor Diamond that that wouldn't be unusual. And it could be like that for up to 6 hours. The jury weren't told that. Sorry. Yes, yes, yes. I'm reminded, of course, that photo was in fact put before Dr. Diamond, and he refers to it at paragraph 2E of his affidavit.
Yes.
So he was obviously aware of the point and has addressed that.
Yes.
As we see there.
Well, if we accept what you're putting to us, that this was really useless evidence to pinpoint timing, what was the Crown case left with, given that, as the judge said, it was essential to their case to put it between this very narrow time frame of between 7 and 7:15 p.m. And this Mrs. Dance, that we obviously got submissions to make about her,
yes.
But beyond that, what else is there, apart from the coincidence of the fact that it's halfway through the
yes.
time frame? Is it really that's all that's all. Left, is it?
That's all, yes. Yes, and of course brain tissue.
Well, yes, quite, yes.
But yes, and that of course is the point. We commend the contents of those affidavits to the court, and to move on quickly. In summing it up, it's respectfully submitted that the uncontradicted evidence at trial as to time of death was not founded on valid science. It was, we say, positively without foundation. Dr. Bezett's evidence was wrong, and Dr. Pang's examination was inadequate, and his reports flawed and evidence wrong. The jury were told, relying on the state of the stomach contents and absence of gastric smell, that the time of death from time of consumption was 1 hour, and essentially not more than 1 hour 10 minutes. That's in essence what they were told. And of course, the evidence that we seek to put before the court and invite the court to accept as fresh evidence is that as a matter of science, those opinions were flawed. That evidence was wrong and wholly inconsistent with the experts we now seek to put before the court. As was said in Bain before this board, at paragraph 115, and we see it at volume 1 of our authorities bundle, if I may, at tab 7. And it's at 3045 at the bottom. And it starts about 6 lines up from the bottom of the page. And thirdly, a fair trial ordinarily requires that the jury hears the evidence it ought to hear before returning its verdict, and should not act on evidence which is or may be false or misleading. And we certainly pray and aid that passage. On the basis of Dr. Pang and Bezett's time of death evidence, the jury were entitled to reject the defence time of death case of post 10:52 p.m. As inherently unlikely, but not so, of course, if one looks at and if they had heard the combined evidence of Professors Knight, Whitwell, Cislatera and Diemel. And of course, they heard from Professor Bezett that the absence of gastric smell was a striking feature. And of course, on our evidence, we suggest that was wrong, and there was no scientific justification for that. So those are our submissions in relation to that ground. Might we move then to ground 5, the computer evidence? The evidence at trial was that in a room used in the Lundy household as an office was a desktop computer. And the evidence was that Christine Lundy would or was in the habit of every evening going and turning the computer off before she retired. On the evidence, this was usually 12 p.m. or midnight. That was the evidence at the trial. On the 30th of August...
Who did that come from? Did that come from the appellant, or
no,
or was that the mother?
That came from the deceased mother.
Yes.
Helen Wedgery.
Yeah.
On the 30th of August, the police found the computer and it was examined, and the last use of the computer was 10:52 p.m. on the 29th of August, when the computer was turned off. There was at trial, as we've already foreshadowed, other evidence that supported the 10:52 p.m. That Mrs. Lundy was still alive at 10:52 p.m. And that was the evidence of the neighbour as to lights still being on at that stage, and evidence from another gentleman who had driven past and seen that the lights were still on, and of course the lights were off when the bodies were eventually found. So this was important evidence, important for the Crown. Their case, of course, was that this was all part of an elaborate plan by Mark Lundy to set up a false alibi, as he did that night, they say, in order to get away with murdering his wife and child. In essence, the prosecution case on this was they could be confident that there had been manipulation, because when the computer expert examined the computer, he found that the files in the registry had been disordered. That was their case. The defence case was that there was no manipulation. And according to the experts, an expert commissioned by the defence, according to him, the disordering of the registry files, in fact, had been as a result of a virus.
I don't think he ever said it was because of it, but I don't think he ever said that it was because of the virus. He said the virus was there, it's the cackworm,
yes,
and the cackworm typically does disorder the registry files. That's
right.
Yeah.
And we'll go back to that in a moment. Of course, during the course of the trial, the prosecution expert disavowed any knowledge of the existence of such a virus. It was put to him in cross-examination that there was this virus called CAC, or a cackworm virus, and that one of the things it did was disorder files. The prosecution expert said he hadn't heard of such a virus, and it was unbelievable that such a virus might contaminate and disorder in the manner suggested.
The disordering was only to supporting material. The virus itself wouldn't have been responsible for the change in time, would it?
No, not at all. No, not at all. But what the way the Crown put it was, it's possible to change the time on a computer without leaving a forensic footprint.
Yes.
If their case was just left at that, it would be mere speculation. But of course, the Crown were able, through Mr. Kleincheese, to say, well, look, we've got support for this manipulation, because it's if you change the date and time in the manner in which we suggest, then that will disorder the registry files. And so that's how they put it.
So the virus explanation was a way of countering that, was it?
Yes.
That was countering that point.
That was countering that point.
Was there any evidence of how long it takes to do what the Crown was suggesting? Because the time frame on their case is very narrow, and you've got to commit 2 murders, and you've got to do all sorts of other things, and then you've got to alter the timing. Does it all fit in with the time available?
Well, the evidence was that it would require a good deal of computer skill to be able to do it in the first place. One, know about it, and two, do it. In the trial, various witnesses were called by the prosecution who conceded that Mr. Lundy was unlikely to have that skill.
Well, it would not take long, though, if the respondent's suggestion of a floppy disk being inserted was correct.
Yes, if one knew what one was doing.
I don't know whether they still have floppies. It seems very outdated technology.
Yes.
I think they were still current in 2002, all right. Yes. But was there any, just to answer my Lord's question, was there any evidence directed to the question of how long it would take?
No. No.
But Mr. Clancy, as you've told us, first of all said he had no knowledge of the cackworm.
Yes.
Secondly, as I understand it, said that it was fanciful that such a thing could have caused the disorder.
Yes.
And did he not also say that this computer hadn't got the virus?
My Lord, that's right.
And on all 3 counts, his evidence was surprising.
Yes, yes. And as the affidavit evidence that we invite the court to accept demonstrates, wrong on all counts. In essence, this on proper examination, it was found to have a virus. And it had been contracted many months before. Yes, yes. And of course, Mr. Chappell, in his affidavit, opines that the virus actually caused the disordering of the registry files. And that's interesting, because in the affidavit in reply by Mr. Kleincheese, he says, in essence, well, that's not right, and I've done tests to prove it. Sadly, he's not told us what tests he did, but what we can do is go to the notes he has supplied in support of that contention. And just, if I can have a moment to find that, we will find that in Dr. Watt's affidavit at volume 16, tab 19.
Volume 16, did you say volume?
Yeah, sorry, volume 6. Tab 29.
Yes, 629, 2407.
Yes.
So am I right in understanding that the only independent evidence that there had been any tampering with the computer was the disordered state of the file registry?
My Lord, yes.
Yeah.
Yes.
And so if there's an alternative explanation for that, I see the significance.
The reference is at 2453. 2453. It's the
yes.
it's next to Dr. Alan Watts's affidavit.
These are Mr. Clancy's notes, are they?
This is Mr. Clancy's notes, and if I we identify them as such at 2453, and these were made available to us recently by the Crown, us having requested to know what tests were carried out. And at 2453, we see what was done and the notes of it, and we say they're quite extraordinary given the fact that in his second affidavit, Mr. Kleinches is saying that cackworm did not disorder those files. Well, he's done a test, and what the test reveals is that they did.
Could you just tell us when he did this?
April this year. Yeah, April of this year.
Oh, recently?
Yes. He did that on receipt of doubtless Mr. Chappell's and Dr. Watts's affidavits.
Okay.
And if I can make the point, page 5 of 10 of his notes, and it's 2458, just
658.
2458.
2458,
Yes.
my lord, at the bottom.
Yeah.
And here we read, it appears according to on case that the file RB001 cab was overwritten by CAC reg file. And that, of course, is the cackworm. We have been unable to determine why the CAC reg file overwrote this file cabinet file. It is possible the cackworm removes the oldest CAB file so that subsequent RB files maintain the infected keys. And then we explored the existing non-overridden cab files, and these are, in fact, the registry files.
Well, he exported rather than explored.
Yes?
Yes. So I think you may have said...
Oh, exported.
Yes.
Yes. And he lists them, RB cab 002, 004, that should read 005, he's made a mistake there. And then we look at what's revealed. And what is revealed is that having identified the cackworm had attacked the registry, we observe that the findings on his tests prove the disorder, because these files should thereupon run from most recent to least sequentially. And of course we can see over the page at 2459, RB044 and RB005 have become inverted. And therefore, on his own notes, we see that in fact he's quite wrong in his affidavit. That is a demonstration that the CAC virus has attacked the registry, and we can see the results for ourselves.
Well, we may be able to, but perhaps we could just take it a little further. RB004, you say, has inverted or been inverted by RB005. Can you just point out to us how you reach that assertion?
It's dates and times, is it?
Yes, dates and times.
They're inverted in terms of date, at least.
Yeah.
Yes.
So
05 to 28.
Yes.
RB004 should be 28, or certainly should be before
Yes.
RB005.
My lord, that's the very point.
It's
it's
as simple as that, is it?
Yes, it's disordered. And it's disordered, we know, because of the CAC virus has attacked that registry, as his test notes demonstrate. And so we find it quite remarkable that... yes.
Somebody does say this apart from you, Mr. Hislop, I'm sure. Who is it?
Yes. It's not Hislop on computers. The affidavit of Dr. Alan Watt,
Okay.
my lord, it's at our tab 29, and that, of course, is volume 6.
Yeah, paragraph.
Paragraph 12D.
Lovely, thank you very much.
I see, yes.
Yeah, that's okay. Mr. Watt says, what I can say is that insofar as the documents provided by Mr. Kleinchees are comprehensible, it appears that the results of his testing accords with mine and Mr. Chappell's. So I am entirely unclear as to why he seeks to draw a different conclusion from it.
It's a slightly elusive reference to RB004 and RB005. I mean, is there any more explicit...
Yes, paragraph 13, the CAC causes the rollback files to become distorted is particularly important because of the essence of Mr. Kleinchees' evidence at trial was that the disordered rollback files was evidence of gross manipulation.
Yeah, but where does he say? Somewhere he must say, presumably because you've got it from him, I take it, that the significant thing is that RB004 and RB005 appear to be the wrong way round.
It's paragraph 12 as a whole. It's really talking about how disordered.
Might I go back to paragraph 12? Therein, there is a reference to the disordering. He doesn't identify with any greater particularity the part of his notes to which we suggest demonstrates the disordering.
For my part, all I want to know is where you've got the proposition that you just delivered to us. I mean, you might have had it in conference, I just don't know.
No.
When did you get Mr. Kleinchees' notes? When did you get them?
Yes, 1 week before Mr. Watts swore his affidavit, which was, we can see that was on the 10th of May of this year.
In C, in paragraph 12C, he's referring to a CD, and that hadn't yet arrived.
Yes.
I mean, has he seen these notes that you've referred us to?
Yes, yes.
Are these the documents, or are they part of the documents referred to in 12B as what's exhibited the affidavit at AW4?
Yes, yes.
The CD was just the photographs of the white.
Oh, yes, in fact, that's stamped on
Yes, it is.
2453.
Yes.
Is there something at page 2425, which seems to be relating to the timings that you told us earlier about? And this is a report presented in the case of Mark Lundy, and paragraph 3 is talking about start-up shutdown files.
Yes.
And it does, about halfway down, talk about the point that the start-up on the 28th should have been the other way round, I think it's saying. Penultimate sentence, the fourth or fifth lines from the bottom of the paragraph, shows the computer having been started up on the 28th of August, which in fact should have been on the 29th.
Yes.
But is it because it's picking up GMT instead of New Zealand time? Is that the...
Yes, I think that's the simple point there. It's just a change.
Yes, it's switched it. I mean, the sequence is all right, but it's
Yes.
picking up the time from the wrong source.
Yes, yes. That's the point there. The rollback files, the point is made by the author of the report at paragraph at the bottom of that page 5, it's 2425, and he's talking about the Crown hypothesis of putting in the floppy disk, and he says, had the date and time, however, been changed during the day at any stage within Windows, and that's the day he's talking about is the 29th of August, it would have shown the new time as the last shown time for that day. However, this at least shows the computer was not manipulated that day and rebooted.
Well, do you have to reboot if you change the time?
For it to disorder the registry files, you do.
Yeah, to disorder the registry files, you do.
What happens with the registry
Well,
files?
I mean, the purpose of changing the time wasn't to disorder the registry files.
No.
But if you use a floppy disk in order to change the time, does that involve a rebooting?
Well, on Mr. Watts's...
We've got a method described on page 2424, haven't we? This is using the floppy disk, bringing up the time date properties window, changing the time. There's no mention of rebooting there, is there?
If you do it that way, you leave a forensic trace.
Yes, yes. I think the point is, and it's covered in the affidavit, is that if one uses the floppy disk technique, one doesn't have to reboot, but what happens is there is in essence a footprint left.
No. That's if you do it through the control panel.
No. No. There is a footprint left in the system's file.
Well, are you sure that's right, Mr. Hislop? I thought the evidence of your experts was that if you used a floppy disk, you didn't leave a footprint.
Well, I may be in error. I'm told to my left I'm in error.
It's very complicated.
Control panel. It's the footprint.
Right. I'm told it's the control panel method of changing that leaves the footprint.
Yeah.
So it's our submission that before the jury, the evidence from Mr. Kleincheese was, in essence, that the disordering of the files gave proof and support to their suggestion or their case that there had been manipulation. And of course they say it was the appellant that did that.
Can I just ask, somewhere there is reference to this computer having been manipulated on at least, I think it was 5 occasions, something like that, beforehand. Was that evidence, could that have been on the material that you've provided us with? Could that have been a result of the CAC virus?
Well, that's certainly not what...
What says it was?
Yes.
What says everything was expected?
Yes. I'm reminded, as far as that's concerned, Dr. Watts's opinion is that all the disordering found was as a result of the CAC virus.
He said he tested a clone of the
Yes.
computer.
Yeah. And in his affidavit, he describes how he tested that proposition using a clone of the Lundy computer. Might I go back to Dr. Watts's affidavit? please, to paragraph 22.
Which page is that?
That 2412 at the bottom, my lord.
Yes, right.
Further, it is suggested that the appellant was testing, in round brackets, playing around or experimenting with date-time changing method. I'm unable to conceive of why he would have been doing so if it is being suggested that he was testing this with a view to ascertaining whether it would be detectable. This would seem most unlikely. The only way one can ascertain if such a step was going to leave a trace behind would be to have a forensic write blocker and forensic software of the type which forensic examiners, such as myself, have to review the drive after testing to see if it made changes. Such software is specialised and sophisticated, and there is no suggestion that the appellant had access to it. And at 22, ultimately, we are presented with a situation where the jury were presented with a very unlikely scenario, that proposed by Mr. Kleincheese, which it was impossible for the defence to refute, in circumstances where an alternative explanation, the effects of cat virus, was apparent, but rubbished by Mr. Kleincheese on the basis of an inadequate and negligent examination of the computer. In short, the jury was seriously misled.
Why was it impossible for the defence to refute it?
That it is addressed in paragraph 18. More generally, I agree that the method suggested by Mr. Kleincheese at trial does not leave any trace. However, it is for precisely this reason that it needs to be treated with extreme caution, lest a jury place inappropriate weight on the suggestion which the defence is in no position to refute. This is a particular problem with forensic computing, as there are many activities one encounters when dealing with digital evidence which leave no trace. This does not mean they are likely to have occurred, or even that there is any plausible basis for suggesting that they might have.
Is this just to say that it's a hypothesis that can't be tested?
Yes.
Yes, I see.
Yes. Yes.
So we'd say speculative.
Yes. Yes. And without the additional evidence of manipulation, that's what the jury would have been left with. But they were, of course, left with the evidence from Mr. Kleincheese that this computer had indeed been manipulated in the way the prosecution put it.
So paragraph 19 is emphasising the problem that the method which Kleincheese was suggesting leaves no evidence.
Yes. And therefore, without other clear evidence to corroborate a suggestion, it would be dangerous to accord it any weight, given that the rollback files were out of order in instant case as a consequence of the CAC virus.
Yes.
This cannot be considered corroborative of Mr. Kleincheese's contention.
Well, it goes rather further than that, doesn't it? It suggests an alternative reason for the disordering of the files.
Yes.
Yeah. Slightly curious way of putting it, that it can't be considered as corroborative. It provides an alternative theory.
Yes.
Which enhances your submission that this is mere speculation.
Yes, my lord. Exactly.
Can you remind me quickly, I'm sorry to take time on this, where the position was left in terms of the evidence with the jury on this point? Was the evidence that, was it that it was a hypothesis?
No, not at all. The jury were left on the basis of Mr. Kleincheese's evidence that the disordering of the registry proved the manipulation. And the only challenge to that was the challenge that was essentially, as Dr. Watts put it, rubbished by Mr. Kleincheese. One is to such a virus existing, and two, it doing what trial counsel suggested it did. I'm helpfully reminded at paragraph 177 of our case.
Yes, this is the submissions for the Crown.
Oh, yes.
Yeah.
Now, as far as the computer is concerned, we know that there is no operational reason which leads to the registry files being in the disarray that Mr. Kleincheese found them to be in, let alone being discovered on previous occasions extensively. And you ask yourselves, why on earth would Christine want to experiment with time, date settings on a computer without leaving a trace? Why would Christine want to do that? The only person who needs the computer to record an altered record of time has to have, you might think, an interest in doing so. And an interest in doing so goes beyond mere curiosity, I suggest, and experimentation. And I accept that for registry files to be in disarray, there had to be an alteration of time and date. But the change of time, the Crown says, was without trace in the way that Mr. Kleincheese demonstrated to you. And so they were very clearly leaving their case on the basis of a manipulation.
And what did the trial judge say in his charge about this?
If I can just...
Well, I don't want to waste time on it because quite a lot of material to get through still.
Yes.
Don't worry, I can deal with that. I can check that myself.
My Lord. So, in essence, our argument, insofar as Mr. Kleinchee's evidence is concerned, is that it was flawed.
Can you just, sorry to interrupt you, I'm just looking at the last bit of the quotation that you see, they're saying, you'll recall, I think, in his evidence, or one of the statements, that he, that's the parent, spent
Yes.
most of the morning on the computer that day before he went to the Lighting Direct shop. He was playing on the computer or working on the computer. I'm not quite sure how that all fits in with the movements we've been contemplating. What? Do you understand that?
Yes, that was the day before. That was the 28th.
On the 28th,
That's the 28th of August before he went to Wellington.
Yes. Now, is it suggested that the manipulation then took place before he went to Wellington? I'm not sure what the Crown were suggesting about this.
I'm not sure what they're saying about that. Certainly there was no sort of evidential link, if you like, and so far as the computer evidence is concerned, in that regard, on the 28th. That's really left hanging by the Crown.
Right.
So we say this is not a case. My Lord, I'm helpfully reminded, volume 4, page 1807, paragraph 14 is where the learned trial judge directs the jury on the computer evidence.
Volume 4.
14, and that is tab 9, and that is volume 4,
Yes.
1807.
Paragraph 14.
Paragraph 14, about halfway down. And the prosecution claims the shutdown of the computer was altered by the accused. This is contested by the defence, and attention was drawn by Mr Behrens to the evidence of the accused's close friend when he said that neither Christine nor the accused was sufficiently competent or knowledgeable to change the time as suggested by the computer expert. There is evidence of lights outside.
Well, I think that's a different point from that on.
Yes. Right. But that is I think the only direction the court of the jury were left with on the computer evidence.
Yeah. But it's made clear to them that if there's a reasonable doubt about death occurring around 7 o'clock in the evening, then that's fatal to the Crown case.
Yes, of course, we emphasise that fact to support our submission that this evidence was important, pivotal, time of death. And of course, this computer evidence links into that. We respectfully submit that Mr Kleinsky's evidence was flawed. This is not a case of the applicant coming along with a bigger and better expert. This is the appellant, through his expert witnesses, being able to point to bad science on the part of Mr Kleinsky's and negligent examination. And accordingly, we say the jury were misled.
From what you say in your case, it rather sounds as though Mr Behrens was misled by what the advice he was getting from his expert at the time, Mr Peacock.
Well, there was it's difficult to understand why trial counsel didn't call Mr Peacock. He maintains in his answer to questions to the board through the registrar that at some time during the course of Mr Kleinsky's cross-examination, he sought leave of the court to speak to Mr Peacock and received from him an answer to a question that trial counsel can't remember. But on the strength of that, he then put a proposition to Mr Kleinsky's, and Mr Kleinsky's disagreed. So on the strength of that, trial counsel decided he wouldn't call Mr Peacock. Now, we just don't know what all that means because the trial counsel can't remember.
Well, yes, but it goes a little bit further than that, doesn't it? You set it out at your 160 in your case.
Yes.
And, I mean, what counsel is saying is, I asked my expert what the Crown expert in the witness box would say if I asked him X. He said he would say Y. I asked it, and he didn't. In other words, I'd been assured that there was only one answer, and I didn't get it. And he's saying that it may have been that caused a loss of confidence in Mr Peacock.
Yes, on one construction, appreciate that. We've tried to find the part in the transcript of that evidence where that might have occurred, and I'm afraid we can't find it. But we simply don't know why Mr Peacock was not called. We've sought to speculate a possible reason that may or may not be right in our case, the appellant's case. If it is, if it was that Mr Peacock was giving wrong advice, then of course one can understand why he wasn't called. But if it's wrong advice, we would respectfully submit that would be an exception, of course, to the issue of freshness, to which we've already earlier referred. We respectfully submit that what was before the jury was bad science, whilst the evidence isn't fresh. That is, the evidence of Watt and Chappell it is excusable on the basis that trial counsel obviously has been misinformed.
Watt had actually reported, had he, before the trial? Or had he simply been consulted and not reported?
No, Mr. Peacock did write a report.
No, I know Peacock did, but Watt hadn't...
Oh, no, not at all.
Doesn't
What comes a lot later after conviction?
Date is 2010, was it?
No, the first time, initially, I think it was in 2002, 2003, for the first time, Dr. Watt was consulted as an expert.
Yeah, that's in paragraph 3 of his affidavit. In 2003, I was approached by representatives.
2003,
Yes.
I see. Yeah.
So that was post-trial. He then moved to Australia and went into the Australian Police Force as an expert, and therefore couldn't become involved in this case. And we sought the assistance of Mr. Chappell, and when the Crown made the assertion that they do that Mr. Chappell might be biased against Mr. Kleincheese, we sought the assistance of Dr. Watt, who by then had left the Australian Police, and that's the sequence.
Thank you.
If it was that the decision to not call Mr. Peacock was, as suggested by trial counsel, then of course it becomes inexplicable that such evidence was not called, because of course of the existence of the CAC virus, and one would have expected a challenge to the suggestion that there was such an infection or virus in existence, and when Kleincheese said it was far-fetched that such a virus might disorder registry files, one would reasonably expect that to have been challenged. At paragraph 177, we've already taken the court to. If the new evidence of Chaplain Watts undermines the evidence relied upon by the prosecution at trial, we suggest, had the shutdown time of 10:52 stood, then of course the evidence of the bedtime habits of Christine Lundy, the glasses, the evidence of the light would have dispelled what was suggested in the police evidence, police interview of Mr. Lundy, that he had suggested in the telephone call at 5:38 to his wife that she should be in bed for 7 o'clock to have sex, and he was coming home for that reason. That was what was being suggested to him by the police in interview. So, of course, the computer evidence...
was that pursued at trial?
No, in fairness, it wasn't, but it was certainly evidence that was there.
Well, I should have thought that suited the defence extremely well. You've got a 7-year-old at home at the time.
Yes, ludicrous proposition, bearing in mind she was still up and about.
Yeah.
Yes, we respectfully agree.
Now, does that end this chapter?
Yes,
How much
that
longer?
does.
We're nearly at, that clock's a little bit slow. We're at about 20 past 12. I mean, I think you have to finish by lunchtime.
Yes. Can I then move shortly, and I
Yes.
can take these points shortly. Ground 6 is the failure to preserve the laptop.
Yes.
179 sets out the position with the laptop. In short, what we are saying in that ground is there was a failure to preserve the laptop by the police. In normal circumstances, it would have been seized and cloned. Now, the evidence at trial was undoubtedly that Mrs. Lundy would have used that laptop that day because she had to do so to complete her brother's tax returns. That was the state of the evidence. So, bearing in mind the importance that the shutdown time on the desktop assumed at trial, and we set out why it is that the police must have known how important that was when they seized that laptop. If this is set out fully in our case at paragraphs 179 right through to 183. And what we say at 164 is that in light of the issues that arise in relation to the history of use of the desktop computer, the failings of the police in respect of the laptop were lamentable, potentially may have deprived the appellant of significant material supportive of his defence, specifically in relation to time of death. And we set out thereafter, in the paragraphs that follow, our submissions on the law. We refer to the well-known English case of Abraham. And of course, the case of Donaldson, which we suggest, and we have a citation 648 there at paragraph 188. That should read 649 for my Lord's record.
Yeah.
Could you, I mean, I understand the proposition, failure to preserve and interrogate the laptop deprives the defendant of potentially at least the possibility of showing that she was using it at about 8:30 in the evening or something like that.
My Lord, yes.
What happened to the laptop?
What happened to the laptop was that on the 30th of August, during the course of the police interview of Mark Lundy mentioned that he had left his laptop at home for his wife to work on his brother-in-law's tax accounts. As a consequence of that, the police obtained a search warrant, and our submissions referred to it, but they got the search warrant. One of the reasons stated in it was that...
Well, it's the short answer, they seized it.
Yes, it's
Yeah,
They seized
what
it.
I'm more interested in is what happened afterwards.
It seized and it's held
Was it handed back to the appellant?
Yes, it was.
It's back
So
on
how
the
can
15th of September.
How can it have deprived him of the opportunity of looking at it?
Because at that time, he wasn't, he wasn't a suspect, in fact, at that time. He receives it, he uses it several months, when by the time the relevance of it is concerned, several months have passed, and we know that because by then the evidence from Mr. was that it would have been simply no longer useful forensically to examine it because of the use of it in the interim.
I think you make that point in paragraph 180.
Yes.
I mean, I've perhaps been a bit superficial in reading this, but I understood it that because it was being in use,
Yes.
it really deprived anybody who was interested in working out what was being done with it at the critical time of the opportunity to get that back in time to work out what was actually happening. I don't understand the mechanics, but that seems to be the point that's been made.
That is the point. That is the point. So by the time the relevance of it was brought home to the defendant, of course, it was in no good condition forensically to deal with and examine. So we say, in the circumstances of this case, the failure to preserve and retain, as one would expect, as in fairness the evidence suggests, Officer Grantham, he suggested to Mr. Kleincheese that he should clone it for that very good reason. And we know that from the terms of the affidavit of Mr. Grantham. And so we say for all those reasons that the defendant has effectively been deprived of the possibility of a defence, and that in the circumstances is an abusive process.
What is the standard that has to be achieved, though? I'm looking at paragraph 188, the quotation from Donaldson.
Yes.
This isn't...
Requiring...
are you saying the defence was obstructed?
No.
That seems rather far-fetched.
No,
It's just,
no.
Is it that there's a failure to collect evidence and preserve it in a way that might assist the defence?
We address that further down. At paragraph 189, we cite the New Zealand Court of Appeal decision in Harmer.
Yes.
And there the two relevant considerations referred to in Donaldson are explained. And over the page, and we have highlighted in bold, and that's our highlighting and not the New Zealand Court of Appeal. When, as here, the issue arises on appeal from conviction, the ultimate question will be whether the unavailability of evidence to the defence appears to have given rise to a miscarriage of justice.
Yes. So one doesn't have to, as it were, put an adjective on the behaviour of the police. It's just simply the effect on the the evidence that was available for the jury.
Yes. Yes, it's the end result.
Yeah, I follow.
Yes. And so they are our submissions in respect to that.
If not accepted as a standalone basis, presumably you rely on this as a cumulative matter in support of the other grounds.
My lady, of course.
Yeah.
It's not freestanding.
You accept that it's not freestanding?
Yeah,
It is freestanding.
Well, it is freestanding. Whether alone it would be sufficient is not a question. It's freestanding, but you call it made for its cumulative effect with the other grants.
My lord, thank you for the assistance. Yes, quite.
Right.
And the submission, of course, is that it makes the computer evidence unfair.
Yeah.
And we make that submission in our case. Ground 7, the unreliable identification evidence. My lords, my lady, you have our submissions there. We don't take them very much further than the written word, as it were. What we say, in essence, is that the learned trial judge certainly formed the view, it would seem, that there was a direction was necessary. The respondents, Pray and Aid, the English case of Queen and Gale, and the distinction between identification evidence and identification through circumstantial evidence. We say that what this case demonstrates, when we look at the evidence of Margaret Dance, is that that distinction is not always a sensible one.
But in this case, it wasn't a case of facial recognition.
No, it wasn't.
At all. It's a very curious description of a very odd incident.
Yes. Which encompassed a description of a round, fat face.
Yeah.
That's about as close as we got to facial features. But what we are saying is that, for instance, in the case of Gale, the evidence really was, the question in that case was whether or not the defendant's right to an identification parade were engaged. And one can understand the distinction that was being made by the Court of Appeal in that case. But of course, the Australian decisions go quite the other way, as we refer 198, where in essence the Australian position is, as much as it's dangerous without a warning in relation to direct visual identification, so it is where you have identification through circumstantial evidence. That's the Australian position. And we, with the greatest respect, submit that, in fact, it is a matter clearly for the trial judge, and in some cases it is sensible to draw the distinction. In other cases it isn't, and in this case it is, and certainly the learned trial judge thought so. And that's how we put the identification. The respondent in their case have referred to issues of the proviso, and we reserve our rights, of course, to come back on those. My lords were asking about Martinga yesterday, and we put Martinga in this way. Having identified a true miscarriage, something that is in a sense of something went wrong, which was capable of affecting the result of the trial. Insofar as Martinga is concerned, the court said it would only dismiss the appeal if, having reviewed all the admissible evidence, it considered that notwithstanding there had been a miscarriage, a guilty verdict was inevitable. So in terms of the instant case, if a miscarriage, if we have identified a miscarriage of justice in the identification of the substance on the shirt and or the time of death evidence, based on other evidence in the case, we say this court could not find a guilty verdict was inevitable, and the court would not be satisfied, we suggest, that there had been a fair trial. And so we say that is the approach in Martinga, and we hope that assists with issues of the proviso. My lady, my lords, unless I can assist any further, that is the appellant's case on appeal.
Yeah, I wonder, there's just one point I'd like to ask you about, and that is the end of the respondent's case, we'll obviously hear from the respondent about it, but part 3 of the respondent's case at page 81, paragraph 300 and onwards, lists, I think, a total of 11, possibly 12 features of the case which are said to support the conviction. This is stepping aside from the points that you've been focusing on. And see that various points. I mean, we've dealt already with the DNA on the polo shirt, but there's also the window forced after the murder, they say, the paint flakes on the tools, the petrol consumption point, the fast, powerful car, the fact there was no phone call made to Amber at her usual bedtime. There are a whole variety of these points.
Yes, I can address all of them, and was going to wait and see just exactly what the respondent was going to say about them.
Yes.
But if I can, keeping an eye on...
I wouldn't want to disturb that unless any of my colleagues would wish to ask you about it. It's just that at some point I would like a response.
Right.
But if you'd rather leave it to a reply.
I'm quite happy to deal with it now. I'm just conscious of the time.
Yes.
Perhaps in the... I don't know how slow that clock is.
It's
12:35.
It's just after 25 to 1. So
Right. Well, maybe I've got 25 minutes
got
then.
about,
Right.
well, if you say, I mean, would it be better to wait and let the Crown get to their feet before lunchtime, and we'll come back with this later? But I just want to make it clear.
I'm in your lordship's hands, but I'm happy to allow the prosecution to. But I'm in your hands.
Well, perhaps it's neater to leave it until we've heard exactly what the Crown are going to make of all of this.
My lord, thank you.
Very well. Mr. Birdling, is there anything you would like to add?
No, my lord.
Thank you very much. Well, Mr. Mentor, I think it's for you to begin.
Please, your lordships, lady.
Can I suggest it'd probably be best if the microphones are switched on?
And the other side too.
Yeah.
Thank you very much.
May I commence by going back to the principles of law that in my submission are in play on this appeal. The Crown has summarised the legal principles which, in its view, govern the admission of post-trial evidence, and they are set out at page 4064 of the bundle. Which in the respondent's case can be found at page 12. So page 4064 of the bundle, page 12 of the case. Evidence that either came into being post-trial, which could not reasonably have been obtained at trial, is fresh evidence. In the respondent's submission, none of the evidence relied upon by the appellant is fresh in the primary sense of that term. This is not a case of scientific developments or forensic advancements since trial, of which the case of Barlow is an example. It is not a case of evidence not being reasonably discoverable at the time of the trial. Evidence that is not fresh, however, may be adduced post-trial on appeal where its absence from the trial can be attributable to counsel error, objectively assessed.
Could it be also justified if it was not produced at the trial because of a non-disclosure? In other words, there was a point which wasn't disclosed, which, had counsel known about it in time, would have been the subject of further inquiries and therefore further evidence.
If the counsel error can be traced back to the disclosure,
yes,
but in my submission, the non-disclosure is the cause or the reason for the counsel error.
I see, right.
Yes, but I think my Lord's asking a slightly different question. If there's no question of error on the basis of the material made available to counsel, but it subsequently transpires that had certain material been disclosed, a different course might have been taken by counsel, that doesn't signify any error on the part of counsel, merely that a different course would have been taken. In those circumstances, is that a further category in which post-trial evidence should be admitted?
It can potentially be, because on one analysis that evidence could be viewed as fresh.
Fresh in the sense that there was no reason to think of adducing it at all until the error was revealed.
Yes, the examination of that issue would have to be analysed in terms of whether or not what is complained about as non-disclosure was something that was otherwise reasonably discoverable. Mm. So in the setting that we have in this case, the respondent will be submitting that what was not disclosed, Dr. Teo's views, were matters, were overtaken by other more relevant examinations in terms of the IHC analysis, but more importantly, had no causal effect because the appellant engaged his own experts who examined the very same issue. And indeed, the matter, the histology, the appearance of the material, that form of examination was subsequently taken over or eclipsed by the more precise, the more conclusive IHC examination.
Well, that may be something that's relevant to the significance of the non-disclosure, but if we leave that to one side for the moment, should the document in which Dr. Teo's observations were recorded, should that have been disclosed?
Yes. Perhaps I should qualify that. The information should have been disclosed.
Yes. Not necessarily the entire document.
Not the document in my submission. And indeed, the fact that the substance is contained in a document of that nature is a very strong clue as to why it was not disclosed in my submission.
Well, of course, it could be disclosed in a redacted form.
Yes.
Yeah.
So just continuing with the relevant principles, where the conduct of counsel was reasonable in the circumstances, was the exercise of a judgment that might have been made by another competent counsel, in my submission, an appeal would not normally be allowed. The error must also be fundamental, in the sense that there is a real risk it affected the outcome. present case, the charge of unreasonable conduct by counsel objectively assessed, as I understand my learned friend's submission, is only made in respect of the evidence as to time of death, but not otherwise. Where freshness nor error in the sense previously outlined can be demonstrated, the court has a residual and overriding ability in rare cases to ensure justice where there is a real concern for the safety of the verdict. But it will not be in the interests of justice, in my submission, to admit further evidence which is helpful to the defence, but which was not before the jury.
I should perhaps indicate that I question whether this is rather austere. The test is miscarriage of justice, that's the ground, and these questions of freshness and counsel competence and so on may be important considerations in coming to that conclusion, but I wonder whether it's not overstating it to put it as a residual discretion to go beyond the case of counsel error or freshness.
Well, residual or overriding, perhaps overriding might be the better description, but in my submission there does need to be a series of gates that has to be
Well, that's what I'm questioning.
gone through. Well, in my submission, it cannot be in the interests of justice for the one trial principle to be completely ignored, as has been alluded to in the respondent's case. There are repeated references in the authorities to the importance of an accused to put forward their best case at trial, and that they can't, after trial, attempt to put forward new evidence or different evidence or approach the matter in a different way. It will not be in the interests of justice, in my submission, to admit evidence which in effect seeks to relitigate the defence case at trial based on recently acquired contesting evidence. And in this that is particularly so in respect of recently acquired expert opinion evidence. Expert opinion evidence which was discoverable in my submission at trial. It is in my submission a legitimate requirement that an accused person prepares their case with diligence and puts their best case forward at trial. And it is not enough post-trial to simply put forward newly acquired expert opinion in order to put in contest evidence which was otherwise not put in contest at trial.
Well, I think that's a fairly straightforward proposition, but I mean, Mr. Hislop's argument isn't as stark as that. He's not just saying, well, I've got lots of fresh evidence and I'd like you to look at it now. We've been exploring a great deal of what actually went on at the trial and why various steps were not taken. So I think one has to take the whole thing as a package of what one's actually got before us today, which is not quite as stark as the point you've just been making.
No, I acknowledge that, Your Lordship. The point I seek to make is that, and this will be examined in some detail before Your Lordships, my lady, but the point that I seek to make is that where is the threshold? Where is the standard? What is the level of cogency of the evidence that must be met before one admits that evidence? And in the respondent's submission and in the respondent's submission in the circumstances of this case, the evidence would have to be very compelling. The evidence would have to be very cogent to the point whereby it demonstrates that the evidence that was put before the jury was wrong, misleading, or indeed inadmissible. Anything less than that in my submission is simply relitigating that which was properly investigated and proper decisions made by the appellant at trial as to the conduct of the defence, which in my submission breaches the one trial principle.
Well, let's just assume that we've got a case of bad science, which has been relied on by the Crown and has also infected the thinking of the defence. The Defence Counsel have also sought advice, and it's been bad science has led to what, in retrospect, was bad advice. Now, if that is the position, then one would have thought the way is open for that to be corrected, simply in the interest of justice, because otherwise there would have been a miscarriage and nobody could sensibly support a conviction which was plainly on the ground of bad science. So when you talk about has to be cogent, it's not so much the new science has to be cogent, it's the reasoning which leads to you looking at it. Is that right? You've got to be persuaded that there was, first of all, bad science on the part of the Crown, and also the reason why it wasn't contested was that the defence were ill-advised. Is that what it comes to?
In my submission, that would be the position, my Lord, that the appellant would need to demonstrate that it was bad science.
Yeah.
So that's a positive proposition, that it must be demonstrated to be bad science before recourse can be had to what I would prefer to describe as the overarching opportunity for the court to admit evidence in the interest of justice. And the reason that I put that question to you is that what if the situation where the evidence that it is proposed to adduce raises doubts about the goodness or the validity of the scientific evidence, and therefore the question is in the air whether, if that evidence prevails, it would raise a reasonable doubt, at least as to the appellant's guilt. Would that be a basis on which it should be admitted?
If the board came to the conclusion that the evidence before it raised a reasonable doubt, the conviction was not safe, I would have to accept that. I would have to acknowledge that, absolutely.
But that wouldn't necessarily impeach the scientific evidence given by the prosecution on the trial as ineffably bad. It would merely raise a doubt as to its soundness.
That is correct, but it would have to reach that point that it was satisfied that a reasonable doubt has been created as to the correctness of the science.
Yes, I see. Thank you.
Yes. I suppose, we're not obviously going to be hearing the evidence, so I suppose the question for us is whether, if the material put before us were to be accepted as credible and reliable, it would then be capable of raising the sort of doubt that Lord Kerr has described.
Potentially, it could, my Lord.
Yes. It may well not be, and it probably is not the appropriate forum. This board is not it doesn't provide the appropriate forum to resolve these issues. Obviously one has to consider the impact of the evidence, but ultimately it may prove necessary to have a forum in which the competing claims of the scientific evidence can be fully explored and resolved. So there may be an anterior stage where we have to ask ourselves, well, does this have the capacity to, if it withstands the test of challenge from any contrary evidence that the prosecution might wish to present to it, does it have the capacity to raise a doubt as to the soundness of the original scientific evidence? Yeah. And then it might be a matter for another tribunal to take that forward.
Yes, with the, as it was discussed yesterday, with the application of Martanger, and it being the responsibility of the appellant court to make that determination.
Well, I mean, as I think Lord Kerr, and I may be putting words into his mouth, we're inhibited by the extent to which we can actually delve into these issues. It's not our function to hear evidence. But if we were persuaded that it ought to be heard in order to resolve the issue, which we can't resolve for ourselves, then the answer would be, well, the Court of Appeal should carry out that task. So, I mean, that perhaps should remain in there as a possible view we would take. And that's something you would have to dissuade us from, obviously, if you're seeking to maintain the conviction at this stage.
Well, certainly, my Lord, the Crown in its case has made reference to Section 8 of the Judicial Committee Act. It's at paragraph 198 of the Crown's case, which obviously empowers the Board to remit the matter back to the Court of Appeal for the purposes of examination and cross-examination,
Right. Yes.
which I understand to be the Board's practice in these types of situations.
Yes.
And I do make the submission that with the application of Martanger and therefore following English cases such as Pendleton, that clearly set out that it is for the appeal court to make that conclusion, for the appeal court to hear the evidence.
That's the substantive question. If there's disputed evidence, I think is what we are discussing here. We may be in a position of saying that if this evidence is accepted as credible, then it raises a doubt as to the safeness of the conviction, but there may still be an issue as to whether it should be accepted as sufficiently credible. It's on that preliminary issue, really, or that the matter would have to be determined by hearing the experts, wouldn't it?
In my submission, it would not be if the Board could come to the conclusion that on the papers the Board is satisfied that a reasonable doubt is potentially available, then that may follow. But in my submission, the Board could not get to that point, having regard to the material that's presently before it, without hearing cross-examination of the expert witnesses, because it is for the Board, for itself, to make the determination as to whether the conviction is safe.
It's not open to us to decide that the conviction may not be safe.
Yes.
It is open to us to decide, depending on how well the proposed new evidence withstands any challenge. And as my lady rightly points out, credibility is bound up with the question whether or not this new evidence has the potential to raise a reasonable doubt.
Well, I wonder, since it's on 1 o'clock, we should adjourn now and resume this interesting discussion at 2 o'clock. Look forward to seeing you there.
Okay.